What I have for you this week is another golden oldie, and it is the Crown Forest Industries court case decision, Supreme Court case decision from Canada in 1995. And I think it's an interesting case. You can see here the date is from 95 because it dealt with Article 4 and it dealt with what it meant to be liable to tax. And remember, this is 95, so the doctrine is not quite developed yet, right? So let's see what was going on. You had New Zealand, Bahamas, US, and Canada involved in this. And in New Zealand, you had a group called the Fletcher Challenge Limited Group, and they had a subsidiary in the Bahamas called Norsk Pacific Steamship Company, and they had a Canadian subsidiary called Crown Forest Industries Limited, which was involved in, I believe, logging and things like that. Now, North Pacific Steamship Company had a office in the US, and it had 19 employees and salary costs, I believe, of $75,000 per month. So it had substance in the US, right? And the US office leased river barges to Crown Forest in Canada from 1987 to 1989, and Crown Forest then paid rental fees for the use of these river barges, and it then withheld 10% withholding tax on these payments as payment for the use of equipment under the royalty article between Canada and the US, instead of the normal Canadian rate of 25%. And the Canadian authorities adjusted this up to 25%, saying that North Pacific Steamship Company was not a resident of the US, even though its place of management was in the US. It didn't really have anything else in Bahamas. So there was also a reciprocal shipping exemption between the US and Bahamas, and this is a national law thing. We'll see it that the US said, you know, shipping companies are exempt if the other country exempt our shipping companies. And the case went from the lower court, the federal court, trial court, as you can see here, where the taxpayer won, to the Canadian Federal Court of Appeal, where the taxpayer still won, but then before the Canadian Supreme Court, the Canadian Revenue Authorities won, right? And the issue was this: are you liable to tax if you are effectively if your place of management is in the US? And now one has to understand that the US, together with Sweden, I believe, are the only two countries where only the place of incorporation of a company accounts for where a company is resident. If you are managed and controlled from the US but you're not resident, you might have a management PE, but you are not taxed as a resident, right? So a 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. Let's see what the court said. The court summarized the facts. They said between 87 and 89, Crown Forest rented barges from Norsk, a company incorporated in the Bahamas whose sole office and place of business was located in the US. Norsk filed income tax in the US only, where it was considered a foreign corporation exempt from US income tax, and accordingly paid no US tax on the barge rental payments. Crown Forest withheld 10% tax on the rental payments as permitted under Article 7 of the Canadian-US Tax Treaty from 1980, rather than the 25% deducted from non-residents, on the footing that Norsk was a resident of a contracting state for the purpose of the convention. Right, so that's the fact. And then if we look at the treaty itself, here is Article 4, and it looks familiar. It says, for the purpose of the convention, the term resident of a contracting state means a person who, under the laws of that state, is liable to tax therein by reason of his domicile, residence, place of management, place of incorporation, which is a specific US court clause, or any other criterion of a similar nature. But in the case of an estate or trust, only to the extent that the income is derived by such estate or trust is liable to tax in that state, either in its hands or in the hands of beneficiaries. So that's the Article 4 from the US-Canada Treaty, and then Article 12 said royalties arising in the contracting state and paid to a resident of the other contracting state may be taxed in the other state. However, such royalties may also be taxed in a contracting state in which they arise, but if a resident of the other contracting state is the beneficial owner, the tax so charged shall not exceed 10% of the gross amount of royalties. And this is why only 10% was withheld. And I assume that a paragraph 3 in this article would define royalties, among others, as they used to in the old days, payments for the use of equipment, right? And then you have the US Internal Revenue Code, and it starts with 864 here, saying for the purpose of this title, income gain or loss from sources without the United States, such as in Canada, shall be treated as effectively connected with the conduct of a trade or business within the United States. And remember, a active trade or business is the US definition of PEs, basically, right? If such person has an office or other fixed place of business within the United States to which such income gain or loss is attributable, and such income gain or loss consists of rent or royalties for the use of or for the privilege of using intangible profits derived in the conduct of business. And then the clause goes on to also include payments for the use of barges. But then 883 comes and says the following item shall not be included in gross income of a foreign corporation and shall be exempt from taxation under the subtitle. And then the first exemption is gross income derived by a corporation organized in a foreign country, such as our Bahamas company, from the international operation of ships or a ship or ships, if such foreign country grants an equivalent exemption to corporations organized in the US. Now, to my knowledge, these barges only operated in Canada, so I don't know how that qualified as international shipping. But the court doesn't say anything, and I will leave that aside here. And then we look at how the Supreme Court analyzes this case. And it says, plain language, in interpreting a treaty, the paramount goal is to find the meaning of the words in question. This process involves looking to the language used and the intentions of the parties. And this is a fact even today still, right? And the court goes on to say something that, whereas you interpret legislation narrowly according with the parliamentary history and so on, the treaties is an agreement between two parties and must be interpreted widely, bearing in mind their intentions and purpose for the treaty, right? The court then goes on to say, at this stage of the analysis, the primary question to ask is why Norsk is liable to pay tax in the United States. If its liability is rooted in the fact that it's engaged in a trade or business effectively connected with the US, then it would seem that Norsk is not a resident of the United States under Article 4, since engaged in a trade or business is not listed as a factor to trigger residency. But then Norsk came back and said, yeah, but hang on, we're also managed and controlled only from the US, right? Under Article 4, it must be shown that the liability to taxation operates by reason of one of the listed grounds. This connotes the existence of some of the causal connection or in the least some relationship of proximity. In my opinion, this is the judge, the fact that Norsk's place of management is in the US is not causally or even approximately connected to the basis of Norsk's tax liability in the US. Quite the contrary. In my mind, the reason why Norsk is liable to tax in the US was because of the income flowing from the business or trade it conducted that was connected with the US. So it's not that you managed and controlled, but it was that you had an office through which you leased these barges. In this respect, the criteria for determining in Article 4, paragraph 1, involve more than simply liable to tax on some portion of income. They entail being subject to a comprehensive tax liability as imposed by a state. In other words, you're only liable to tax under Article 4 if you are subject to your to tax on your worldwide income, as was the case in the US and Canada for residents, because they didn't apply generally a territorial system, right? And then the court goes on and talks about the role of the OECD commentaries, and I like this because it goes on to say clearly the purpose of the convention has significant relevance to how its provisions are to be interpreted. I agree with the intervener government of the United States submission that in asserting these goals and intention, a court may refer to extrinsic materials which form part of the legal context without the need to first find an ambiguity before turning to such materials, right? And this is, among others, the UN of the OECD Model Convention and the commentaries. I think the court goes quite far, because now we are purely in treaty interpretation, right? And the intervener from the US government, just to understand, is that the case was between Crown Forest Limited and the Canadian government, but the US thought, this is about treaty interpretation, so the government of the United States asked if it could intervene in this case and also say what it thought about the treaty and about Article 4. Right, so it is the U.S. government representative here that says that you can look at extrinsic materials even when the treaty is not ambiguous. Now, this goes a lot further than the Vienna Convention, but the judge goes on and says reviewing the intentions of the drafters of a taxation convention is a very important element in delineating the scope of the application of the treaty. Of course, it depends on what the source about the information of the intentions of the drafters is. If it's just someone that happened to have attended a meeting, their interpretation of what the intention of the drafters were might be something different than the next person, right? In the case at bar, I underscore that there is no need to prevent double taxation because the US has declined to tax Norsk's revenue. Allowing Norse to benefit from the convention in this case would actually lead to avoidance of tax, because then there's no withholding tax either, right? The goal of the convention is not to permit companies incorporated in a third country, in the Bahamas, to benefit from a reduced tax liability on source income merely by virtue of dealing with a Canadian company through an office situated in the US. Now, I'm quite sure that the advisors that advised the structure at the time thought that this was a very clever idea, right? Under the respondent's interpretation, this is what the judge says, a foreign corporation whose place of management is in the US would be a resident of the US for US purposes of the convention, notwithstanding that such corporation may not have any effectively connected income to the US and hence no US tax liability at all. I find this possibility to be highly undesirable. And again, it's this quirk in the US, right, that you can have an effectively connected business. It might not you can be managed and controlled from the US, but not have any effectively connected business in the US and therefore not be taxed in the US at all, because the US doesn't tax based on residency, based on place of effective management. It taxes based on residency, based on place of incorporation, right? This result, the court says, would be patently contrary to the basis on which Canada ceded its jurisdiction to tax as the source country, namely that the US as the resident country would tax the income. And I think this is an important sentence. It's probably one of the most important ones in the whole decision. Canada gave up its right to tax, and there was a reason for it. And the reason was that the income will be levied the tax will be levied in the US and vice versa, of course, right? And if that doesn't happen and you are not a resident, I mean, if they were a resident and the US doesn't tax, that would have been a whole different case. But they're not a resident, and this is what this case turns on. So the court then goes on and says, I now turn to another set of extrinsic materials or other international tax conventions and Article 31 and 32 of the Vienna Convention on Law of Treaties, which indicate that reference may be made to these type of extrinsic materials when interpreting international documents. But it does not say that you can do that when there is no ambiguity, like the US government says, right? Of high persuasive value in the terms of defining the parameters of the US-Canada treaty is the OECD Model Tax Convention on Income and Capital. I totally agree. As noted by the Court of Appeal, it served as the basis for the US-Canada treaty and also has worldwide recognition as a basic document of reference in negotiation, application, and interpretation of multilateral and bilateral conventions. And I like this case for what the judge says here, because there are a number of academics out there saying that the OECD commentaries are only supplementary material because it is not part of the basic common understanding of the treaty partners, right? And the court contradicts that here, and I think anyone who says that it doesn't form part of what is in the minds of the treaty negotiators when they negotiate a treaty does not understand how the negotiation of treaties happen. Typically, treaty negotiators get together, they take the OECD Model Convention, and they talk about the paragraphs in the commentary that they don't agree with, or the articles that they don't agree with, because that is a much, much shorter list than the list of those things that they do agree with, right? So the court then goes on to say, look at Article 4 of the OECD Model Convention, and it is pretty much like what it is for US-Canada, except it has a second sentence. It says, but the term does not include any person who is liable to tax in that state in respect only of income from sources in that state or capital situated therein. This is quite a big difference. And the taxpayer said, you know, because the US-Canada treaty does not have this clause, therefore it means that even if we just are subject to source taxation, in the case that we are not already subject as a resident because we are managed and controlled from the US, then you know, we still are entitled to the treaty benefits. But the court says the underscored sentence does not form part of Article 4 of the US-Canada Treaty. Nevertheless, as I discussed below, I reject the respondent's argument that the failure to reproduce the second line of the OECD Model Convention residency definition indicates a desire to permit even those only liable for source income to qualify as residents under the US-Canada Tax Treaty. And the court then goes on to explain why this doesn't apply. And it says, the authority for the proposition that only those who are liable to tax on their worldwide income can justifiably be considered residents for the purpose of the International Tax Convention is found in the first sentence of Article 4 of the OECD Model Convention, and the absence of the second sentence does not detract from that, right? So they say the first sentence is quite clear, the second sentence is merely an explanation, actually. And then the court goes on to explain, and it refers to some history from OECD as well, and it says, this is because the second sentence is relevant to a situation in which a person is considered a resident under domestic law, but where that person, by reason of special privilege, nevertheless is not subject to tax on his worldwide income. And then it refers to paragraph 8 of the commentary. Nowadays, this is paragraph 8 and paragraph 8.1 in the 17 Model Convention, which says, in accordance with the provisions of the second sentence of paragraph 1, however, a person is not considered to be a resident of a contracting state in the sense of the convention if, although not domiciled in that state, he is considered to be a resident according to the domestic laws, but is subject to only to a taxation of limited to the income from sources in that state, e.g., in the case of a foreign diplomatic or consular staff serving in their territory, right? So the second sentence, and I've not always read the second sentence like that, I must confess as well, it references not only source income, like withholding taxes on interest and royalties, but it also covers this situation where you are a resident, but you're only subject to limited tax because you are a foreign diplomat or something like that. And then the court goes on to say the OECD Model Convention is not the only international agreement worthy of consideration as extrinsic material. And they bring up a very interesting point. They say, I also draw from the UN Model Convention, Article 4 of this convention, and Article 4 of this convention does not contain the second sentence, but in the commentary thereto recognizes that in order for a person to be a resident of a contracting state, that person must be liable to tax in that state on its worldwide income. So again, proof that you don't need the second sentence. By the way, I looked at the 17 and 21 UN models. The second sentence is now included. Maybe it was not in 12, but it definitely was. It was not included in the older models, as the court says here. And then to conclude, the court says the intervener, this is the US government, makes several informative submissions that support the conclusion that was expressly intended by the US to have residence under the convention determined only by place of incorporation. It noted that Article 4, Paragraph 1 of the OECD Model Convention does not contain place of incorporation as grounds of residence, right? However, recognizing that place of incorporation is the only criterion that has any relevance to the determination of worldwide tax liability. Under US law, the US entered a reservation to Article 4, Paragraph 1 for the right to use place of incorporation as an indicator of residence. Otherwise, the US can't tax any company as residents, right? However, in order to preserve overall conformity with the OECD Model Convention, the decision was taken not to remove the other OECD criteria from Article 4, Paragraph 1. Nevertheless, the place of incorporation is the only term in Article 4, Paragraph 1 that governs the determination of the residence of a corporation in the US for purposes of its tax conventions. So it's not that they ceded this point or anything like that. They simply kept the rest of the text just to be a little more uniform with the OECD Model Convention. That's how I read the judge here. And the judge then concludes, as a result, the courts below erred in limiting Crown Forest's non-resident withholding tax to 10% instead of 25%. I consequently would allow the appeal with costs, and the appeal was made by the Canadian revenue authorities because they lost the previous 2 times, right? So I hope you enjoyed this case. I think it's an interesting case. I think it brings up some interesting aspects of Article 4 that we don't always consider. And again, you know, these old cases, doctrine that we take for granted today, at some point was very new and needed to be thought through and argued through. And I think the court did an excellent job of doing so. I look forward to discussing the next case with you next time. Bye for now.